Welcome, everyone. Today, we're going to unpack a really intense legal battle over a single-family home in Lewiston, Idaho. Now, this might sound like a simple property dispute, but trust me, it's so much more. It's a story that pulls back the curtain on America's entire foreclosure system, where court rules and some really serious allegations of fraud just smash right into each other.
And, what's so wild about this case, right from the start, is that even the lawyer on the other side admitted in open court that the homeowner's arguments were logical and sound. That little comment right there tells you this is not your average eviction case. This is a story about a fight for justice against what seem like impossible odds.
Okay, let's dive in. Here's how we're going to break this down. First, we'll get the lay of the land with the foreclosure itself. Then, we'll dig into the auction that sparked the whole controversy. After that, we'll look at the buyer's legal defense, how some crucial evidence got kicked to the curb, and finally, we'll zoom out and see how this one case in Idaho plugs into a huge nationwide system.
So the whole story revolves around this one house at 1515 21st Avenue in Lewiston. On one side, you've got the homeowner, Jeremy Bass, and on the other, you have these two corporate investors, DPW Enterprises and Mountain Prime 2018 LLC, who scooped up the home at a foreclosure auction. Now, the legal process that kicked all this off is something called a non-judicial foreclosure. It's a tool used in Idaho and a lot of other states, and really, you got to understand what this is to get what's happening here.
So what is it? Well, in a nutshell, it lets a bank or lender take your house and sell it without ever going in front of a judge. The whole thing is handled by a third party called a trustee, who's supposed to be a neutral referee. Making sure all the rules are followed so the sale's public and fair.
And that brings us to the absolute core of this fight. See, the homeowner isn't really arguing about a missed payment. No, he's making a much bigger claim. He's saying the auction itself, the very event that took the title out of his name, was a complete sham from the get-go. All right, now let's get into the juicy part. Let's look at the actual evidence that makes you wonder if this auction was fair at all. This is where the story really gets wild.
The main allegation from the homeowner, Mr. Bass, is that this wasn't a real competitive public auction. He argued it was basically a backroom deal, all prearranged to snap up his property for way, way less than it was worth.
And the evidence he pointed to was pretty stunning. First, the buyers actually admitted in a court document that they'd contacted the trustee before the auction. Then, get this, they show up to the auction with cashier's checks already printed out for the exact winning bid down to the penny. The price they paid allegedly wiped out hundreds of thousands of dollars in home equity. And to top it all off, there was a huge sign in the front window of the house for over a year, basically screaming to the world that there was a conflict over the title.
In a court filing, and this is a filing the judge later refused to even look at, Bass just lays it all out. He says their own admission of talking to the trustee beforehand is direct proof of bid rigging, which, by the way, is a federal felony.
Okay, so with all these bombshell allegations flying around, how in the world did the buyers fight back? Well, they used a really powerful legal shield that's designed to keep property sales from being reversed.
It's called being a bona fide purchaser, or BFP for short. It's a legal status that basically says, hey, if you bought a property honestly, paid a fair price, and had no clue there was anything shady going on with the title, then the sale is final. The whole point of this law is to make sure real estate deals stick.
But, and this is a huge but, that protection has very clear limits. It'll save you from small mistakes you couldn't have known about, but it gives you zero cover for your own fraud or if you colluded with someone. And it definitely doesn't protect you if you had a direct warning of a problem, like a giant sign in the window. The homeowner's whole argument was that the buyer's actions put them way over on the unprotected side of that line. And this is the actual law right here. The whole legal shield depends entirely on that one little phrase, a purchaser in good faith for value. If you didn't act in good faith, that protection just vanishes. So, naturally, this became the central battleground of the entire case.
So, how did the court deal with these two completely different stories? Well, this is where things take a sharp turn, because the biggest claims, they never actually got a proper hearing. Just look at this timeline. In the crazy week right before the big hearing, legal documents were just flying back and forth. The homeowner files his big response. The other side replies, but they throw in brand new arguments. So, the day before the hearing, the homeowner fires back with his final documents, directly answering those new points, and spelling out his fraud claims in detail.
And then, this happened. At the very start of the hearing, the judge just announced she wasn't going to consider the homeowner's last filings. She said that,
Based on court rules, you're not allowed to file a reply to a reply. And just like that, the documents with the most detailed evidence of collusion were wiped off the record.
So the takeaway here is absolutely critical. The corporate investors won the case, but not because a judge or jury decided the auction was fair. They won because the evidence claiming it was fraudulent got thrown out on a technicality. The court granted what's called a summary judgment, and the case was over, without anyone ever digging into the substance of the claims.
So let's zoom out for a minute, because what happened in that one Idaho courtroom really isn't just about one house or one case. It's a tiny piece of a much larger, very well-oiled national industry that does one thing: foreclose on homes.
When you start to map out who's who, you see it's a pretty small world. Carrington, the company servicing the mortgage, has people who speak at conferences for the American Legal and Financial Network, or ALFN. The law firm for the buyers, they're a member of ALFN. The trustee who ran the auction, also a member of ALFN. They are all swimming in the same professional pond.
And you have to remember the history here. A lot of us recall the robo-signing scandals after the 2008 financial crash, where firms were just faking documents on an industrial scale. That whole mess gave rise to these specialized foreclosure mill law firms that just churned through thousands of cases for the biggest banks, and even for government-backed giants like Fannie Mae.
And this is why this story really matters. This case isn't just a weird one-off. It's a perfect window into a national system with its own rules, its own incentives, and its own interconnected players. It really shines a light on this massive power imbalance, where sometimes following the procedure can matter more than fundamental questions of what's right and what's fair.
Which leaves us with this one last really big question. This case basically forces us to ask, can perfectly following court procedures be enough to make a sale valid, even if there are credible allegations that the whole thing was fraudulent from the very beginning? It's a direct clash between the rules of the game and the spirit of justice, and it's a question that really gets to the heart of what fairness means in our legal system.